Hello and welcome to Legal Pitfalls to Avoid in Security Incidents. My name is Nick Merker. I'm a partner at Ice Miller, which is a law firm based in the Midwest. I'm currently sitting in Greenwood, Indiana, but I'll be presenting this live at Black Hat in Las Vegas as well. You can reach me at nick@icemiller.com. There's a link to my LinkedIn profile, and of course you can find me on Twitter at @nmerker. So let's just kind of jump in what I want to talk about today. First, so who's this lawyer and why is he here? Why am I interested in this security incident talk, and why am I giving it at Black Hat? Well, so before becoming a lawyer for about a decade, I was an information security professional. I was a systems, network, and security engineer in a variety of roles, one at a large.com. I've been in the public sector, and I kind of transitioned that experience into a legal career, where today I head up the data security and privacy practice at the law firm Ice Miller that I mentioned before. And the reason I'm really interested in this topic is I work a ton of security incidents. I've probably worked, I've acted as a data breach coach for maybe 500 or more security incidents at this point, and they range from everything you could possibly imagine to someone leaving a laptop in a car that had some customer information on it, to some of the largest ransomware events that you might have heard of. And the thing that I've found in these events time and time again is that IT professionals, security folks, people that are not lawyers, because that's not what you do every day, find yourself in this weird situation of a security incident where you have to think like a lawyer, or at least have a lawyer there to help you understand some of these legal minds that you can walk on. And the things that we're going to talk about today in particular are attorney-client privilege, and I'm going to spend quite a bit of time on attorney-client privilege because this is becoming more and more of an issue. We'll be talking about cyber risk insurance. We'll be talking about other things in this area like OFAC and the new advisory opinion that came out in October, and how that's really dramatically changing the security incident game, at least in terms of ransomware. And we'll be talking about some other things as well. So what I'm going to do with this talk is try to focus on things that I've experienced and issues that I've run across, and how they could have been easily avoided by just having a conversation or just thinking about the event as a lawyer for a second. And although many of the folks who are going to be listening to this might not be lawyers, I'm hopefully going to give you a little bit of a toolkit that you can think like a lawyer in these situations, at least think about those minds that I was talking about. So let's jump into attorney-client privilege first. So if you're not familiar with attorney-client privilege, we've all heard about this on TV, or maybe you've read an article, or maybe you've listened to a podcast where someone has mentioned, oh, I can't say that, that's attorney-client privilege. Well, what does privilege actually mean at the outset? And I'll just spend a couple seconds on this. So what attorney-client privilege is, the whole purpose of it is to make it so a client who wants to seek advice from an attorney can say whatever the heck they want to that attorney, and they know that that attorney is not going to go off and share that information with somebody else. And more importantly, that attorney cannot be compelled to testify against that client. That's really kind of the whole focus of attorney-client privilege. So if you come to me and let's say you say, you know, I murdered someone 5 years ago, I can't then go to the police and go, hey, I found your murderer, because you would have established an attorney-client relationship with me. I can't disclose that. Now, of course, there's exceptions to attorney-client privilege. If you came to me and said, you know, in about 30 seconds I am going to murder someone, well, then I'm actually ethically compelled to disclose that, to try to prevent that from occurring. But, you know, for past wrongs, your attorney cannot disclose that information. But there's many misconceptions about attorney-client privilege. The first is, not everything you say to an attorney is privileged. Now, your communication to me, if there's an attorney-client privilege or attorney-client relationship, might be a privileged communication, and the content of our discussion may not be disclosed, but that doesn't mean the subject matter of that information is privileged. You can't, for example, disclose a bunch of facts to an attorney and then have that attorney say, well, my client can never talk about these facts ever again because of the attorney-client privilege. My client told that to me, so no one can get these facts out. So underlining facts are not going to be privileged. And this is really important in a security incident because most of what we do is going to involve an attorney. And I'm going to talk about attorney-client privilege. And when a regulator asks me to disclose information, or maybe I'm asked in a court case to disclose documents or information about our investigation, I'm going to say, hey, we did this investigation in anticipation of litigation, and I'm not going to disclose any of this to you because it's privileged information. But that doesn't mean that the underlying facts in the security incident are also privileged. For example, if the attacker got in through compromised credentials through some Citrix account, that just because that was told to an attorney at some point doesn't mean that that fact is privileged. That's just an underlying fact to the event, and those facts are not privileged. My analysis on your notification obligations or the fact that I can't be brought to testify against you, that's what privilege is going to protect. So this is an important thing to think about. Also, you want to think about waiver of privilege. You can at any time choose to just waive your privilege. And if you waive privilege, there's some jurisdictions that say you waive privilege on absolutely everything. You can't pick and choose waiving privilege. For example, there's a case that stands for a situation where a forensics provider wanted to disclose portions of a report to a non-lawyer. And so what they did is, I think it was a regulator, and so what they did is they redacted portions of their forensics analysis, their forensics report, and they disclosed the portions with redactions to that regulator. Well, a court in that case said, hey, you can't have your cake and eat it too here. You can't take a privileged document, redact parts of it, and then cherry pick the good parts that you like and disclose that to regulators. If you disclose any portion of this document, you're going to waive privilege on the whole document. So that's something you really need to be careful of, and I'll be talking about that in a second. So there is a major opinion that happened earlier this year in this Clark Hill case. This was a security incident case where a plaintiff brought an action against Clark Hill, and really at the thrust of this case, or this memorandum that I'm really focused on, is a motion to compel the defendant Clark Hill to produce all reports of the forensic investigation into the cyber attack that led to the public dissemination of this plaintiff's confidential information. And they also wanted the court to force the defendant to provide answers to interrogatories that kind of got towards the subject matter of that forensics report. And what happened in this case, and I'm going to go through the details in a second, what happened in this case is that the court said, hey, you didn't meet your burden to show that this report or a similar document like the report wouldn't have just been created in the ordinary course of business irrespective of litigation. So the whole purpose of this investigation, which was done by Duff and Phelps, as you can see here, the whole purpose of the investigation, they said, was to, or Clark Hill and Duff and Phelps said, hey, we did this report and in anticipation of litigation, meaning we are creating this document in preparing for defending ourselves from this exact lawsuit. And the court, which reviewed the report, said, no, I just don't buy that. Based on the information that I have in front of me, I do not buy that. How did this happen? So the first, and this is a lot of text, so I'm just going to tell you what this says. So the first argument was they created this engagement letter. And in the engagement letter between Clark Hill and Duff and Phelps, they said, hey, we are doing this investigation and preparing of this report in anticipation for litigation. And it had it straight up in the engagement letter. And that has been a best practice forever. And it still is a best practice. I'm not telling you that this is not a best practice. This is still something that you should be doing. They said, hey, we're going to have an engagement letter. We're going to say we're doing this at the direction of counsel in anticipation of litigation. And the court said, look, that's not enough. You can't just paper privilege. You have to act like it's also a privilege investigation. And they focus on a couple things associated with the investigation. The first is, although you took this two-track investigation, and this is another best practice that I still advise folks to do, if you want some investigation to be privileged, you're doing a litigation defense investigation, that investigation should be done separate and apart from your ordinary course investigation, as you see in the quotes here, your ordinary course business investigation where, look, you need to respond to the security incident. You need to have somebody come in and do an investigation, just discover facts. What happened and what's the company going to do to get all their systems back? That is one track. That is the e-Centire track here that they tried to say. That was our ordinary course investigation. And then they tried to say we had this special Duff and Phelps investigation, and that investigation was done in anticipation of litigation. But the issue, and you see in the bottom little bucket here, the court said, look, the problem here is that this two-track story was not supported in the record. All they had to support it was a statement from somebody in the organization that said, yeah, we did this investigation in anticipation of litigation. They actually, they alleged that there was really no separation here. They may have had this separate outside party that was assisting in this ordinary course investigation, but it really, I mean, it was, the Duff and Phelps work really was the ordinary course investigation as well, is what the court said. Then, but now again, you should continue to do these two-track investigations, and I advise clients in your incident response plan to have a two-track approach where you have your ordinary course investigation and then a completely 100% separate team is doing the privilege investigation. So although the court said that paper privilege and this approach was not enough here, and we'll get to why on actually the next slide, you really should have this two-track investigation if you want to try to preserve privilege of these investigations. Then the other issue that they ran into was, hey, you can't just share this Duff and Phelps report that you say is privileged all across the organization and act like it's a privilege investigation. And that was another issue here where they said that this was shared with the board of directors, this was shared widely, as it says in this quote, throughout the organization, and that's something that cut against this being a privilege investigation. So the sum up of this approach is, if you want to protect privilege in an investigation security incident, you have to, one, paper it up. You have to have that engagement letter that we saw on the first slide. And the engagement letter should say, hey, I'm doing this in anticipation of litigation. This is going to be a privilege investigation. You should continue to do your two-track investigations. But then you have to only, and this is the big one, you have to only use that report for litigation preparedness. You can't use that report as your ordinary business outcome report, meaning you're not taking this privileged investigation report and giving it to directors in the organization, talking to the board about it on saying, hey, here's what Duff and Phelps found. They said we need to deploy multi-factor authentication. They said, we probably should have some sort of patching strategy, and we have none. And that type of stuff done to the board, and I don't know if Clark Hill did this in this case, I'm just kind of opining, that type of stuff is what's going to break privilege. And then, again, don't share the report. Don't share it in a redacted form. Don't share it to regulators when they ask. Stand by your privilege, because once you share it, you're going to waive it. So for those in the audience who are saying, I'm not really involved in this investigation process, this is not something that I deal with every day. Well, you deal with this every day in a security incident. And this is a completely fabricated email chain, so I redacted it because it's my personal email address that I redacted twice. But in this situation, I get this all the time where I'm on the bottom here. I will send a communication to one of my clients. I'll say, hey, I'm doing this analysis, and based on the analysis that I found, I don't think data exfiltration occurred. And here's the reason why I came up to that conclusion. And then I'll always have something like, this isn't a 100% foolproof legal analysis because I don't have all the logs. We didn't have enough logs in this situation. Some of the logs got purged because we tried to get everything back online so quickly in this ransomware event. So there's some legal risk here. And then what will happen is someone in the organization will send that top email. They'll say, hey, Bob, the lawyer said we need to deploy endpoint monitoring because there wasn't enough information to make the formal conclusion that he wanted to make. And that's a major problem if the person sending that email and Bob are not part of this privilege chain. And this email at the top, let's say Bob is an IT director and Bob is sending it to the CISO. No lawyers are copied, no lawyers are involved. This is Bob taking, actually whoever is sending this is taking action on that investigation, taking action on my advice internally in the organization and breaking that wall of privilege. This is going to waive privilege on my email if you send this communication. So I always advise clients, be very careful when you're communicating about results of a security incident. If a lawyer sends you an email, then don't take that email and forward it on. Also, don't go down to the water cooler and just start talking outside of the kind of walls of privilege to other folks in the organization, because the last thing you want to have happen is you sitting in the audience right now or sitting across from me, well, it wouldn't be me because I don't really practice litigation, sitting across from someone like me who is deposing you about information that you learned about this incident. So maybe you're going to be part of this lawsuit with Clark Hill and this plaintiff, and you were going to get deposed because you were an individual that had information about this investigation, and you waived privilege when you sent that email. So you do not want to get deposed. I will tell you that right now, and this is the type of stuff that will land you in deposition land. Similarly, let's kind of switch gears real quick and talk about another area of major risk that I'm seeing with organizations. And this is this October 1st, 2020 Department of the Treasury OFAC advisory on potential sanctions for facilitating ransomware payments. You've probably heard about this advisory opinion because it's really kind of changed the landscape of the ransomware market in terms of response. And also in terms of just attackers, it's a lot hard for them to get paid because of this. And so that landscape is also changing dramatically. But I'm going to focus on how this is changing the legal landscape and how this is impacting your incident response. So if you're not familiar with OFAC and what they do, this is from the advisory opinion itself. And essentially, as you can see, U.S. persons, and I'm reading from line 2, U.S. persons are generally prohibited from engaging in transactions with individuals or entities on OFAC's specially designated nationals and blocked persons list, other blocked persons, and those covered by comprehensive country or region embargoes. And this is strict liability. This does not care if you intended to pay Iran or Cuba. If you pay Iran or Cuba and if you're an intermediary, or maybe it's 4 entities down the line pays Iran and you were involved in the process at all, this is strict liability. So your intent does not matter. And importantly, these designated entities, as listed, or persons you see in the quotes, OFAC has designated some ransomware players, like those involved in CryptoLocker, WannaCry 2.0, Evil Corp, or involved with Drydex and SamSam, and this is all from the advisory opinion, have all been designated as entities. And more could be designated in the future. I would imagine we're going to get DarkSide, although they're not really operating anymore. I imagine they're going to be a designated entity coming on down the line, and there's going to be others that are heavily involved in those public, very, very public types of events that are going to get to be designated entities. And if you're an intermediary or you pay those folks directly, you can get strict liability that can result in up to $1 million in a penalty or 20 years in prison for each violation, or it can be civil penalties up to 55 grand a violation, and there can be seizure or forfeiture of goods involved. We actually saw this with the Colonial Pipeline event, where a ransom was paid, and then the Department of Justice had that memorandum and a court filing that got made public as part of that press release, where they were actually able to seize some of the cryptocurrency that was paid. And I don't know if they seized the cryptocurrency when it went to an exchange, like it was in your or my hands, or if it was still in the attacker's hands. I don't know that. I don't know if anyone knows that outside of that DOJ group that performed the seizure. But essentially, that a payment was made in cryptocurrency to that group, and the DOJ was able to seize $2 million in cryptocurrency, Bitcoin, of that payment. And so this is something where your goods can be seized. And it just as an aside, that really had a dramatic effect for a couple days on the price of cryptocurrency, if that type of seizure can happen on these cryptocurrencies that folks thought were completely separate and apart from that type of regulation, that really did tank the price of those cryptocurrencies for just a couple days, as just a quick aside. So, how do you avoid this? So what do you do? If you're in a ransomware event, you need to pay the ransom because your company can't get back online, the attacker or threat actors got the backups, it's completely impossible for you to get back online. Well, the advisory opinion says what you should do. The advisory opinion says, hey, in advance, and you should do this in your incident response plan, I'm about to talk about that, have a risk-based compliance program. Build into your IRP a structure on how you are going to analyze whether you're going to pay a designated entity or not. And you may not know with 100% certainty in these events, and you're going to take a little risk doing so, but having that risk-based approach built into your incident response plan is an arrow in your quiver. The second arrow in your quiver is to engage law enforcement immediately. You can see in the last paragraph, if you have a self-initiated, timely, and complete report of a ransomware attack to law enforcement, that's going to be a significant mitigating factor in determining their outcome. That doesn't mean that they're going to completely walk away, but let's say you have an incredibly risk-based approach compliance program where you're analyzing the Bitcoin wallet, you're analyzing everything about the threat actors, communications in your negotiations with them, you're doing absolutely everything you can to determine, am I paying a sanctioned entity, what am I doing here? And then you also engage law enforcement very, very early on. Let's say down the line, 2 years from now, it comes out that attacker group you paid was part of a designated entity. You didn't know at the time. It is still strict liability, but these arrows in your quiver are going to be helpful to you when you stand in front and say, hey, I did everything your advisory opinion told me to do. And you're probably going to get, if you do these things that they said, you're probably going to get less of a penalty, or maybe even no penalty if you follow these steps. But again, it's not a complete shield because it's a strict liability. Again, intent does not matter. If it's later determined you paid this sanctioned entity, it could be a problem for you. So this is the area that I'm super worried about with my clients. I'm more worried about the delays. So because of this advisory opinion, it has dramatically changed the game on how payment works in these events. So if you just go back 2 years ago, if I had a client that an entire system was offline and they needed to pay the ransom, they had no choice whatsoever. All they could do is pay to get their systems back online. They need that decryption key. We would just tell the insurance carrier, hey, we're going to make this payment. It's within limits or it's outside of limits and we'll eat the cost, whatever. And the carrier goes, okay, yeah, go ahead. That's no longer the case. Now, and you can see this is from a endorsement on ransomware for a major insurance carrier. This is just their policy language. And I want you to focus on the last sentence. Ransomware loss means those funds paid by the insured to the perpetrators of the attack to end the attack, and then here's the magic language, with the insurer's prior approval. Now, and this is how every cyber risk insurance policy works. You have to get the insurer's approval before you make some payment, whether that be to Duff & Phelps, whether that be to me, whether that be to any vendor, and also whether that be to a threat actor for a decryption key. And the prior approval process now is delayed because an insurance, just put yourself in the insurance carrier's shoes. There's strict liability if you're an intermediary on this OFAC problem. So an insurance carrier, they have a lot to lose. They want to make payments all the time on behalf of their insureds. One of these insureds might pay a sanctioned entity, and that could have strict liability onto the insurer. So the insurer is going to want to make sure that you are not paying a sanctioned entity. They have a whole compliance process built in that could take hours. In some cases, it might take days. It depends on the threat actor group, how much is known about them, how good your risk-based compliance program is, just how good you can show the insurer that, hey, I've done everything I can possibly do here. We are not paying an attack, or we are not paying a designated entity. There's no OFAC problem. Please let us make this payment. But then you might run into another delay, and that delay is going to be at your bank. This is a set of questions that I received from a bank in relation to a client that wanted to take funds and make a threat actor payment. Then we had delays at the bank. And the bank wanted all of this information. Now all this information is readily available. It wouldn't be that hard to get that information, but if you know large banks, just like large insurance companies, just like any entity, compliance is not a quick process. So once I give this information to the bank, it might be a 2-day delay. It might be a 1-day delay. It might be an hour's delay before the bank goes, okay, you can take this money and you can pay this threat actor. Because the bank is in the same boat that the insurance carrier is in, which is the same boat that you're in. So this is a major deal. And getting all this information might take work, and then paying on this information, or getting the bank to agree to pay, might also take some time. So what should you do? The real focus here is this immediate. If you're going to engage in threat actor negotiations, ask the threat actor for their cryptocurrency wallet immediately, engage outside counsel immediately, and start analyzing this issue immediately. Because you may have a 48-hour negotiation process for the threat actor payment. You may have a 72-hour. You may have a 24-hour. Whatever that timing is, if you start working with your carrier, your bank, and every other intermediary about 2 hours into the event, you're not ready to make a payment yet, but you are making these negotiations, and you're also on the side in parallel working with all these intermediaries to say, hey, here's who I'm going to pay. I don't know the amount yet, but I need your rubber stamp on this. because I want to make payment when I want to make payment. Because as you know, every hour that your business is down to a ransomware event costs you money and may cost you sales that will never come back in some industries. So getting in touch with this immediately is something that you really want to do. And then also, I'm going to focus, switching gears real quick. Actually, before I do this, let me take a really quick aside because I have time. The really quick aside is on cyber risk insurance. The cyber risk insurance market is dramatically changing because of ransomware events. So many cyber risk insurance policies, the premium might be $50,000 and the aggregate limit for a year might be $5 million. This is just rough math. And so let's say someone has a ransomware event where they need to pay $2.5 million to an attacker. In many of those events, the BI, business interruption claim, is also tied to the same aggregate limit as the cyber risk insurance. So you have a $5 million business interruption claim. So if you're paying an attacker $2.5 million, you're paying me, let's say, $40,000. You're paying a forensics provider $100,000. You might be paying another entity $100,000 to get all your systems back online. And then let's say that you are having a business interruption loss of $2 million. Well, we've hit $5 million. And so if you're paying $50,000 in premium and you hit a limits claim, that's called, meaning you have $5 million of loss, you're going to get $5 million minus your retention back from that insurer. So that insurer has paid out $5 million on a $50,000 policy. And you can very quickly do the math to know that they're going to have to write a lot of policies to people that don't have these events in order to make a buck off of it. And that just hasn't been the case. There's been way more ransomware events than I think anyone could have ever predicted, and way more limits claims than I think anyone could have ever predicted. And we're seeing a dramatic shift in the cyber risk insurance market because of that. You're seeing increased premiums. You're seeing some carriers that are doing sublimits for ransomware events, meaning that instead of getting that $5 million limit I talked about, you're getting a $250,000 limit. And if you want a bigger limit, you're going to pay a higher premium. You're having some carriers completely leave the market in some industries. You're just having a massive, massive shift in this area. And I would strongly advise you, in many companies, it's the CFO or the finance team, maybe a little bit of attorney flavor that are part of that procurement, but cybersecurity needs a seat at the table in cyber risk insurance procurement. And so I would go to your CFO, your insurance person, whoever makes those purchases, talk about this issue, because if someone's making the decision to not buy it because premiums go up or limits change or whatever, or maybe there's new subjectivities on coverage, like there was a subjectivity last year to you don't use SolarWinds because they had that issue at the time last year. That was a subjectivity to coverage, meaning if you do use it and you said you didn't, we're not going to provide coverage. So this is something that cyber risk needs a seat at the table in procuring cyber risk insurance. Okay, with that, let's switch gears. Last thing I want to mention is actually using your incident response plan. Everybody has an incident response plan. I'm going to make that hand wave statement. If you don't, I just said you did, but everybody has an incident response plan. Not everybody, in my experience, uses an incident response plan in an incident situation. And it is critically important, and I'll tell you why, and you can find it in NIST Special Publication 861, the Computer Security Incident Handling Guide. And here's why it's important. Now, you may not adhere to NIST, you may do something else, but what NIST tells you to do in your incident response plan is why this is so important. And focus on incident documentation in this document. Incident documentation, you're having this logbook where you are documenting a summary of the incident, a status of the incident, a timeline, a logbook with major decisions, and that's for you to build up this kind of story of what you as a company did, because when someone starts asking, and it's going to be a regulator or a plaintiff, you can tell the story of what you did and why you did it. Oh yeah, 24 hours in, we made the major decision to pay the threat actor because we used net backup and net backup was encrypted and we have no offline backups. And you want to know when that decision was made, who made that decision, and why it was made. And that is something that's done in this incident documentation. Similarly, this will also help protect chain of custody, which is really important because if you do want to preserve privilege in that two-track investigation, you want to make sure you don't accidentally waive privilege. Your incident documentation is going to have contact information for everyone involved. I'm harping on this. It's the least exciting thing that I'm probably talking about, but when I work an incident and the company is not building documentation on what we did, why we did it, and the like, and the timeline in particular, it makes it really hard to answer questions from insurance carriers to get reimbursed, it really makes it hard to answer questions from plaintiffs and the like, and so you want to have these in your documentation so you can do those things. Now, that doesn't mean you should always generate a forensics report. I could talk about that for an hour, but there might be reasons to not generate a forensics report because of that privilege issue earlier. So you may tell your forensic vendor, I don't want you to generate a report because I don't want it to be in the hands of a plaintiff, and so I just don't want that document to exist. That could be something that a decision that companies make, but that's not what I'm talking about here. I'm talking about establishing those underlining facts that are not going to be privileged. Those underlining facts that you can describe, here's my timeline, here's major decisions we made, things like that. And that is legal pitfalls to avoid in security incidents. I really want to thank you for your time in listening to this. If you want to talk to me at all, I'm at nmerker on Twitter, nick@icemiller.com, and you can find me on LinkedIn there, and enjoy the rest of Black Hat. Take care.